Ladies and gentlemen, it's time now for the much-awaited bicentenary lecture. May I respectfully request the Chief Justice of India, Dr. D.Y. Chandrachud, to kindly address this audience.
Good evening. My distinguished colleagues from the bench, Justice Bhushan Gawai, Justice Dipankar Datto, Justice T.S. Sivagnamanan, Chief Justice of the High Court of Calcutta, judges of the High Court of Calcutta, and judges and Chief Justices who are serving the nation in other high courts, my very dear sister, Indira Di, Justice Indira Banerjee, my very dear brother and friend, Justice Aniruddha Bose, distinguished senior members of the Bar Library Club, Shri Ananda Kumar Mitra and Shri Jayant Kumar Mitra, Mr. Ajay Krishna Chatterjee, the acting president of the Calcutta Bar Library Club, members of the Bar Library Club, esteemed guests and dear friends. The last time that I tried my hand of speaking in Bangla was on the occasion of the farewell of my very dear colleague, Justice Aniruddha Bose. But that was a relatively easy target audience because I believe that about 3 to 5 people in the audience knew Bangla. Today is a little more tricky for me because almost everyone in the audience, with the exception of perhaps Justice Gawai and I, is adept at the language. But I thought I must begin by speaking to you, and what better way to speak to you on such an auspicious occasion than through the heart. আপনাদের সবাইকে আমার আন্তরিক শুভেচ্ছা আর অভিনন্দন। আমি কলকাতায় আসতে খুব পছন্দ করি। তাই ইনভিটেশন পেতেই আমি এখানে আসতে রাজি হয়ে যাই। কলকাতা আমার প্রিয় শহর। কলকাতার ইতিহাস, ঐতিহ্য, সংস্কৃতি is reflected in every stone, every pillar, and every arch adorning the High Court. This commanding venue, the Town Hall, is steeped in a unique history of its own, as also in Kolkatar Manusher Mishti Byobhar. Kolkatar passion, love of the arts, cricket and football, energy for discourse and dissent, ekebare atulniyo. আমি বাংলা সাহিত্য, গান আর সিনেমা পড়েছি আর দেখেছি, unparalleled in every way. সময় থাকলে আরো খানিকটা বাংলা বলতাম। আপনাদের সকলকে অনেক ধন্যবাদ যে আমি আমার প্রিয় শহরে আসতে পেরেছি। নমস্কার। It is with immense pride that I stand before you today to celebrate the 200th anniversary of the Calcutta Bar Library Club. With its rich legacy and heritage, this institution has truly been a cornerstone of the legal community in this state and indeed for the entire nation. We have heard during the course of the presentations and speeches by the previous speakers of the galaxy of talent which has been contributed by the Bar Library Club not only to the history of West Bengal, to the history of the freedom movement, to the public life of the nation, to the arts, culture, truly the best that the Bengali tradition signifies. Established in 1824, the Bar Library Club has witnessed the evolution of our legal systems over 2 centuries. It has been a spectator, not a silent spectator or a mute spectator, to historic trials, landmark judgments, and the careers of some of the most illustrious of legal minds. The walls of our venerable institution have heard the eloquent arguments of legends such as W.C. Banerjee, the first president of the Indian National Congress, Dr. Radha Binod Pal, the only judge who dissented from the majority judgment in the Tokyo trials, Mr. Subimal Roy, who was elevated directly from the bar to the bench in the Supreme Court of India, Niran Dey, who I heard as a young 13-year-old child in the Keshwanand Bharati case, Ashok Sen, with his sheer forensic brilliance, to name but a few. Each of them has left an indelible mark on our legal history, and many have spoken highly of the club. There has been a great amount of cross-fertilization and cross-migration between my parent High Court, the High Court of Judicature at Bombay, and the Calcutta High Court. Chief Justice Chittatosh Mukherjee, genteel to the core, but a man of steel. As a young lawyer, I was a witness to a tumultuous meeting when the bar decided to boycott several judges of the Bombay High Court whom we believed had transgressed the line of judicial behavior. And we decided to impose the boycott. Chief Justice Chittatosh Mukherjee responded by saying that I am withdrawing work from these judges. What tremendous courage that the Chief Justice must have, coming to a different High Court and saying that I am going to withdraw work because my bar has stood behind the cause of judicial independence. But genteel to the core. I remember as a young lawyer, so many of us would go to Grant Road Market on Saturday morning only to watch our Chief Justice Chittatosh Mukherjee, dressed in a Bengali dhoti and a kurta, going to buy fish with a basket in hand. Chief Justice Manoj Kumar Mukherjee, with his mastery over criminal law. Chief Justice A.M. Bhattacharjee, who had a tremendous grasp over the fundamentals of law. Never mind what happened in his career. We must acknowledge the good that lies in every human being. Chief Justice Sabyasachi Mukherjee, who had the courage to tell even the Supreme Court when they stayed a proceeding before him, and he said, let wiser heads decide. But also due credit to the Supreme Court of the time, that when a judge of the Calcutta High Court had said, almost in indignation, when the Supreme Court had stayed a proceeding before him, let wiser heads decide. Yet the Supreme Court felt the wisest among them, namely Justice Sabyasachi Mukherjee, had to be elevated as a judge of the Supreme Court. Those were the traditions. Since its inception, the Bar Library Club was an exclusively male preserve, until the likes of Namita Gopal, Maya Ray, Leela Seth and Rumapal, who later became a judge of the Supreme Court, joined as members. This inclusion was a significant step towards gender equality in the legal profession. These trailblazing women have not only broken barriers and the glass ceiling, but have also paved the way for future generations of female lawyers. Their contributions have enriched the club's legacy and inspired a more inclusive and diverse legal community. This sums up the idea of inspiring inclusion to me. Your own personal achievements can have an immensely powerful influence on others who follow, who see what you have done and realize their own aspirations are achievable. Setting a tangible example for others makes a real difference to diversity within the profession. The Bar Library Club has been truly a center for good fellowship, not just for good learning, for professionalism, but for good fellowship. A very distinguished journalist and artist, Desmond Doig, has said, there is a sense of judicious levity, particularly in the Bar Library, to suggest that the law has a sense of humor and a heart. In Mumbai, we also have a great deal of camaraderie and friendship at the bar. We had two very distinguished professionals, two brothers, one of whom became a judge, the other remained at the bar. With a great deal of affection, we used to call the judge Doctor, I will not take the name, We used to call the judge doctor. We used to call his brother who remained at the bar compounder. There is a story about the compounder, the younger colleague who remained at the bar. He walked out of the court deeply miffed at the fact that the single judge had not merely declined to grant him relief but dismissed his petition summarily. So the client from the district perhaps walked up to this lawyer and said, "What happened? You were telling us that we had a fairly good case." So he looked very somberly at the client and said, "The single judge who was sitting alone told me that this case is so complex that I cannot handle it. You will have to go before two judges now." So that was the beginning of the letters patent appeal then in that case. On 4th of July 1860, a resolution was passed by the Bar Library Club that no conversation which takes place inside the club will be repeated outside, and with justification. So many things which are spoken of in the Bar Library Club are sufficient proof against the operation of the laws of defamation, particularly in relation to the judges. Very often, in our own club, the corresponding Bombay Bar Association, you would hear a senior member or a junior member coming to the club and say, "Samajh to nathi." The man didn't understand what I was arguing. But these are the traditions. No malice, a sense of joy, a sense of camaraderie, an understanding of the human failings and the human drama that takes place every day of our lives in the courts. But I want to talk to you about 2 or 3 important issues which have been close to my heart. The first issue that demands our focused attention and a united and determined response is encouraging women's empowerment and increasing their participation in the legal profession to achieve the maximum representation. Strides have been made towards achieving greater gender representation. We put out a report in the Supreme Court called The State of the Judiciary last year as part of the Center for Research and Planning, which found that women now constitute about 36.3% of the working strength of the district judiciary. Interestingly, in state after state now, in the course of competitive examinations for recruitment at the lowest level of the judicial service, over 60% of the recruits are now women. That shows you the social evolution which is taking place in India. But while progress has been made in terms of gender representation, there remains a pressing need to ensure that our judicial institutions are truly inclusive and accommodating for all. It is concerning to note that despite the presence of female lawyers, amenities and facilities catering to their specific needs are sorely lacking. Women often have multifaceted identities, balancing household tasks and child-rearing responsibilities alongside their professional careers. Managing both the domestic and professional spheres can be a daunting exercise for women. The expectation that women shoulder dual roles as caregivers and as professionals highlights the need for supportive policies and environments within our legal institutions. One of the steps which we took after I took over as Chief Justice of India was to provide for a wholesome meal to every member of our staff, a large number of whom consist of women. We have over 2,000 employees in the Supreme Court. And a young law clerk who came to me yesterday to bid me farewell said that one important thing that we had done was to provide for a sum of 25 rupees, a meal for every member of the staff, which consists of a few fulkas, rice, dal, vegetables, and a sweet at the end. And she said, "Sir, so many women who have no time to cook for themselves in the morning, but yes, must come to the workforce every day, avail of this facility." A small initiative like this makes such a big difference to the empowerment of women. So empowerment of women is not in the big ticket things, but in small issues where you make a difference to the lives of women. Recently, my colleagues at the Supreme Court, Justice Suryakant and Justice K.V. Vishwanathan, directed the Supreme Court Bar Association to reserve the post of treasurer for a woman in the upcoming elections, as well as 3 out of 9 posts in the working committee and 2 out of 6 in the senior executive committee. The Bombay Bar Association in the city of Mumbai has similarly adopted a change in its bylaws to allow for more women to be elected as members of the association. I urge our legal fraternity to build on these initiatives, ensuring that they translate into meaningful actions that foster a more equitable treatment for women and environment for women. Encouraging diversity and inclusion strengthens our legal system and enriches the perspectives that drive justice. We must continue to support and mentor young women entering the profession, ensuring they have equal opportunities to excel and lead. The Supreme Court of India had designated in 75 years of its history a total of 13 women as senior counsel. In February, with the great and tremendous support of Justice Gawai and Justice Khanna, and the Attorney General and the members of the bar who are our colleagues on the committee, we designated 12 women in one shot in one particular selection. The legacy of the Calcutta Bar Library Club is a testament to the progress we have made, but it is also a reminder of the work that still lies ahead. The second issue which I want to address this evening is the lack of professionalism among advocates. This may be one of the major reasons why the standards in so many of our high courts and in the district judiciary have taken a dip to a depth that eminent judges and quality advocates do not get the recognition that they deserve pan-India. In today's times, common citizens feel that adjournment has become a routine part of the judicial system. This perception is disheartening, as adjournments which were never intended to be commonplace have now become normalized within the judicial process. This leads to prolonged litigation, increased costs for litigants, and delayed justice, ultimately eroding the public trust in our legal system. My experience over the last 24 years is that far more difficult than delivering judgment, far more difficult than engaging with the lawyers in a complex case, is the difficulty of the judge in getting a lawyer to open a case for argument. But surely that has to change. Let me draw an analogy from a Hindi cinema. In the movie Jolly LLB, there is a notable scene where the protagonist, a struggling lawyer named Jolly, confronts the courtroom dynamics and challenges prevalent within the legal system. In one instance, Jolly observes another advocate manipulating evidence to favor his wealthy client, revealing the ethical compromises and injustices that can occur within the legal system. This fictional portrayal vividly reflects real-world concerns, where professionalism and ethical and standards are sometimes compromised, affecting the credibility of legal proceedings. The nursery for developing a professional bar lies in mentorship by seniors, and that is where institutions like the Bar Library Club are so crucial to our profession. I joined the chambers of Mr. Temtan Andhyarujana, a very distinguished member of the original side of the Bombay High Court, who later on became Solicitor General of India. When I walked into his chamber, I wished him good morning and I said, "Good morning, sir, and I'll be happy to work on any brief that you give me." And the first thing that he told me was, "There are no sirs in this chamber. Learn to call me by my first name, Temtan." Now that is the tradition of the original side of the Bombay High Court. It's not the tradition on the appellate side of the High Court. Because on the appellate side, you have lawyers who come from the rural areas. There's a sense of respect. There's a certain degree of hierarchy. But what this did was, and I thought I'll mention this example, when my senior told me to call him by his first name, and I then called him by his first name until he passed away a few years ago, was that he was trying to indicate to me the intellectual equality of every member of the profession. By calling him Temtan, I was not running him down. After all, he was the head of chambers, the head of the family for all of us juniors in the chamber. But there was this intellectual equality, a feeling that we are not there only to learn, but we would teach a thing or two even to our senior. Payment to juniors must be commensurate with the work which they put in. Too often, as seniors, we believe that juniors come to us to learn. And because they come to us to learn, where is the question of paying the juniors? I think times have changed. Though we live in our traditions, we can't live in the traditions of 1860. Young juniors who come to us to learn come with the hope that they will be able to make a dignified living out of the legal profession, so that they do not have to cut corners to make that little paltry money to survive in a big city like Kolkata or in Mumbai or Delhi. But more than anything else, I wanted to share this story because we as judges of the Supreme Court have law clerks. I have learned over the last 8 years that while I have mentored my law clerks, every single day that I interact with the law clerks, I learn from them more than I give to them. Because the younger generation in our profession reflects the voice of the community, the voice of our society. Perhaps as senior lawyers, senior judges, we may become disconnected with society by our own eminence. These youngsters have a pulse of society, and there's so much that we can learn from them. And therefore, in the Supreme Court, we have put together a scheme for open recruitment of young law clerks. This year we held an open examination over 22 centers in India. We recruit young law clerks on the basis of a competitive examination. We had over 8,000 young lawyers who applied for recruitment as law clerks for a total of about 90 positions in the Supreme Court. We pay them 80,000 rupees for the first year and 90,000 for the second year. I believe you pay 35,000 in the Calcutta High Court. Every city has its, of course, own standard of living and other things. But the reason why I mention this is that it's very important for us to set parameters. It is important that the way in which we recruit young juniors to our chambers must mark a break from the past. Recruitment of young juniors to chambers should not be on the basis of purely networks. Justice Gawai spoke about the need to ensure that youngsters from the marginalized groups come into the profession. Youngsters belonging to the marginalized segments of our society are not part of networks. They lack cultural capital. They do not have the sense of cultural capital which the more affluent amongst young lawyers have. So how do you then attract them? You can attract them by creating a level playing field. The recruitment of over 60 or 70% women lawyers into the district judiciary has an important moral for us. When you create a level playing platform, a level playing field, you open yourselves as a legal profession to people without connect. And it is only then that we'll be able to truly make ourselves an equal opportunity profession. But mentorship of the bar also involves a crucial role for judges in the court. Mentoring young lawyers is equally the function of a judge. Recently, just 3 weeks before we closed, my bench of 3 judges in the Supreme Court was dealing with a very important case which arose from the state of Gujarat, dealing with the recruitment of additional district and sessions judges. We were dead against the petitioners. The respondents argued and we were completely with the respondents. We heard the petitioners in rejoinder, quite a few eminent counsel, and we were dead against them. And the last voice to be heard was of this young woman lawyer who is a junior at the bar. We heard her for about a minute, thinking that we'll hear her for about 2 or 3 more minutes and then wrap up the proceeding. In those 2 minutes, she started making a dent in the opinion of the court. At the end of 15 minutes, she had completely swung the bench in her favor, and the judgment ultimately went in favor of the petitioners, which is truly an indicator that real talent today also rests in the junior members of the bar. Of course, we venerate the seniors because they bring the voice of experience. They are the stabilizing influence in the profession. They are the people who will tell the juniors when they get excited, when the passions of the moment take the better of juniors, when they run into difficulty with a judge. The seniors are the people who will caution restraint. That these are the ups and downs of the profession which you have to handle. But truly, we have to make more space for the juniors in our profession. So much of time is lost in courts. When I was appointed as Chief Justice of the Allahabad High Court, I realized that when references are conducted for deceased members of the bar, the court would rise for the day after the reference was over. The bar would insist that after the reference was over, there would be no further judicial work. When my father passed away, I was a young judge of the Bombay High Court, and the bar came to the Chief Justice and said, Chief Justice, a distinguished former member of the bar who became Chief Justice of India has passed away, and we'd like the work to be closed at the end of the reference. The Chief Justice wisely said, well, his son happens to be a member of our fraternity. Why don't you go across to the chamber of my brother Dhananjay and ask him what he would like to do? I had a suggestion. I said, why don't we begin the reference half an hour before the closing time of the court? The reference will probably get over around the closing time of the court, at which point the Chief Justice may then say that the remaining part of the judicial work for the court would remain suspended, which meant that the court went on for pretty much the whole day. We adopted the same thing in the Calcutta, in the Allahabad High Court. And I would really request a little bit of a rethink on the part of all of you. Should we be at all ceasing work because a member of the bar has passed away? Well, of course, we respect our friends, our colleagues, our seniors. Sometimes, unfortunately, they are our peers who have passed away untimely. But do we need to affect the wider society at large? Every minute of judicial time which is lost, is judicial time lost in answering a case of a litigant who is crying for justice? An NDPS accused who has been denied bail as a carrier for the last 3 years. We get so many of these cases coming in from the hinterland. Should we not, therefore, be very serious about the fact that we shouldn't be losing even a minute's time of court working time? And we can alter our traditions. Our traditions can be suitably altered to pay respect, yet at the same time, make ourselves in tune with the demands of modern society. And I'm sure that you will continue to do so, build on the traditions, yet move towards the needs of modernity. The third thing I want to speak about is resistance to technological advancements within our legal profession. Technology is not a privilege reserved for the elite. It is a tool meant to enhance the delivery of justice to all. Just as sunshine is the best disinfectant, technology can serve as our greatest asset in eliminating inefficiencies and opacity within judicial processes. I hear numerous stories in my court where advocates have embraced technology, which in turn enhances access to justice in remarkable ways. Today I had the great honor and privilege to sit in the Chief Justice's court at the Calcutta High Court, something I'll treasure for the rest of my life. One thing which I appealed to all members of the bar was that we have video conferencing. Please appear through video conferencing in the Supreme Court from the Calcutta High Court. Your litigants know you the best. You have conducted the trial on the original side or in the city civil court. You have conducted a first appeal or a second appeal or a civil division. You know the face of the client. Who better than you to make the presentation before the Supreme Court? The adoption of hybrid and virtual court hearings, video conferencing, these have significantly reduced delays caused by physical distance. These technological innovations allow hearings to proceed efficiently, even when participants are geographically dispersed. It means that litigants, especially those in remote areas or facing mobility challenges, can access judicial proceedings more readily. It bridges the gap between legal services and those who need them, ensuring that justice is not delayed due to logistical barriers. Today, legal research has become revolutionized with unprecedented access to databases, online journals, and e-books. What once required days of efforts can now be accomplished within hours. The integration of artificial intelligence and machine learning is also transforming how we sift through vast amounts of information, making legal research more efficient and insightful. Over the last 1.5 years, we have been translating every one of the 37,000 judgments of the Supreme Court into each language which is recognized by the Constitution using machine learning and, of course, teams of district judges, because human verification is necessary. All 37,000 judgments have been translated into Hindi. Over 11,000 judgments of the Supreme Court have been translated into Bangla, which explains why I think I've tried my hand at a little bit of Bangla this evening. Amidst these technological advancements, libraries like the Calcutta Bar Library Club retain profound significance. Albert Einstein famously remarked, "The only thing that you absolutely have to know is the location of the library." The physical space of a library holds a unique sanctity, a place where knowledge is cherished, not merely stored. Libraries don't just store knowledge, yet cherish knowledge. Since its inception, the club has epitomized meticulous and labor-intensive legal research. Many of you may have spent hours poring over tomes, cross-referencing cases, and honing arguments with precision, fostering a deep understanding of the law. The Bar Library remains an invaluable resource where tradition and innovation converge, supporting a culture of readership and offering more than just books. It is a sanctuary for learning, reflection, and growth. The role of bar libraries in providing access to curated collections is pivotal, particularly for young lawyers and scholars. Membership rules should ensure that these resources remain accessible to all, regardless of background or financial means. Their accessibility is essential for ensuring equitable access to legal knowledge and resources, bridging gaps for marginalized communities who often face barriers in accessing legal information. These libraries should serve as inclusive spaces where legal professionals from diverse backgrounds can access comprehensive and reliable resources to enhance their understanding and practice of the law. By maintaining accessibility and inclusion, bar libraries contribute significantly to fostering a more equitable legal profession and supporting professional development across the legal community. I don't know how many of you know this, but all the judgments of the Supreme Court are now placed in the digital format, the digital SCR, which is a resource which is available free of charge. The Digi SCR reads like a book. It's an exact replica of a book. Please use the Digi SCR because you do not have to subscribe to it. Users can conduct free text, case type and year, judge and bench strength searches facilitated by Elasticsearch technology for quick and efficient retrieval of judicial decisions. Ensuring accessibility through initiatives like conducting regular workshops for junior lawyers led by senior members of the bar might be beneficial for nurturing professional development and enhancing a legal skill. These workshops would provide invaluable mentorship, guidance, and practical insights that are often not fully covered in formal legal education. Practical aspects like courtroom procedure, case management strategies, advocacy skills, and ethical considerations could be covered in these sessions. I remember in our small reference section of the Bombay Bar Library, there was a senior member of the bar by the name of Mr. Kharseji Baba. Mr. Kharseji Baba was a quintessential Parsi. He had a very colorful tongue, as many seniors in the bar libraries have colorful tongues. So when we went to the reference section in search of an authority, he would first give us the choicest epithets in Parsi Gujarati. But then he'd call you and say, "Well, what is it that you want?" And I would say that, "Kharseji, I'm looking for this point on excise law." He would tell you, "Come and sit here." And he would tell you, "Well, the classical case on the point is Bombay Tire International. It has been distinguished in a particular case. It followed in a particular case. has almost been overruled on a particular point while distinguishing the case. So this was the sort of mentorship which we received from senior members of the bar. In conclusion then, let me say that the Bar Library Club was established in 1825, 37 years before the Calcutta High Court was established in 1862. What is the moral of this story? The Bar Library Club predates the Calcutta High Court, but what is the moral of the story? Now, reflecting on this, the moral is that we judges come and go. We are just pilgrims on the path of justice. But the bar as an institution is forever. The bar is a representative of the eternal values on which our society is founded: justice, equality, dignity, liberty, and fraternity. You know, Deshbandhu Chittaranjan Das, in his defense of Sri Aurobindo in the Alipur bomb blast case, said, the accused, he said, is standing not in the bar of the court, but in the bar of the High Court of history. And I thought that these are prescient words for every generation. Said the accused stands not in the bar of the court, but in the bar of history. Long after he is dead and gone, he will be looked upon as the poet of patriotism, as the prophet of nationalism, and the lover of humanity. So I then leave you with this thought that what does the Bar Library Club symbolize? What is this tradition that we have inherited, that we hold in trust, and that we are expected to pass on to the future? And that is this tradition of being not just a professional body, but a literary body, embodying within ourselves poets of patriotism, prophets of nationalism, and lovers of humanity that we all are. And it is in that tradition of the Bar Library Club that I salute all of you for being the inheritance of such a great tradition of the Calcutta High Court. Since I've come here for the first time, I thought I should take a little longer than I was assigned. My first visit to the Calcutta High Court as a young lawyer was when I had barely put in 2 years of practice. My clients were the Union of the Railway Protection Force, as I was sharing with the judges a short while ago. The greatest luxury that was bestowed on me was an Indian Airlines ticket to come to Calcutta to argue the case, which I thought had made my day and year. I didn't get any fee for the matter. When we landed in Calcutta, I was taken to the waiting room of the Howrah railway station where we stayed for the night. My two clients, the President and the General Secretary of the Union, slept on the carpet below my bed, giving me the great luxury of being the sole occupant of the bed. We went back. I was deeply pleased that though I didn't make a single rupee as a fee, I got my first appearance in the Calcutta High Court. Little did I realize in 1984 that I'll be here 40 years later, bestowed with this great honor of addressing the members of such a distinguished institution. Thank you very much.
And with that, ladies and gentlemen, we come to the end of the program. Our gratitude to all the distinguished guests for gracing this function